The use of algorithmic decision-making tools in employment has revolutionized how administrators make crucial decisions in the workplace. Resume scanner software applications prioritize job applications by analyzing specific keywords, helping employers identify the most relevant candidates. Employee monitoring software is used to assess employees' performance by analyzing factors like keystrokes or other relevant metrics, providing insights into productivity and efficiency. Virtual assistants or chatbots are used to engage with job candidates, ask questions about their qualifications and skills based on predefined criteria. They reject candidates who do not meet the requirements. Video interviewing software is used to conduct interviews remotely, assessing candidates' facial expressions, speech patterns, and overall communication skills as part of the evaluation process. Testing software is used to evaluate applicants or employees based on multiple factors such as personality traits, aptitude, cognitive abilities, and cultural fit. It may involve game-based assessments or traditional tests to determine job fit. These algorithmic decision-making tools have become invaluable in streamlining processes such as recruitment, retention, promotion, and performance evaluations. Employers embrace these technologies to enhance objectivity, productivity, and efficiency while aiming to minimize bias and resource consumption. However, as we navigate this evolving landscape, we must address an important question. Do these algorithmic tools unintentionally perpetuate disproportionate adverse impacts? Are they inadvertently causing negative consequences based on factors protected under Title VII of the Civil Rights Act of 1964, such as race, color, religion, sex, or national origin? To shed light on this matter, the Equal Employment Opportunity Commission recently released new resources on artificial intelligence and its relationship to Title VII. The focus is on examining employers' selection procedures, the methods used to make critical decisions such as hiring, promotions, and terminations, and determining whether these selection practices have an adverse impact that contradicts the principle of Title VII. First, what is EEOC? The EEOC, or the Equal Employment Opportunity Commission, is a federal agency in the United States that plays a crucial role in combating workplace discrimination. Established under the Civil Rights Act of 1964, the EEOC is responsible for enforcing laws that prohibit employment discrimination based on various protected characteristics, including race, color, national origin, sex, religion, disability, and age. The agency investigates and resolves complaints of discrimination, promotes equal opportunity, and enforces laws related to equal pay, pregnancy discrimination, and genetic information discrimination. Before we discuss adverse impacts of AI and algorithm-driven employment selection procedures, let's clarify a few terms. Software refers to programs or procedures that provide instructions to a computer on how to perform specific tasks. Application software, also known as an application or app, is a type of software designed to assist users in performing specific tasks. In the context of employment selection procedures, different types of software and applications come into play. Consider whether your organization uses software to automate resume screening, manage the hiring process, employ chatbots for hiring and workflow management, conduct interviews, analyze data, monitor employee activities, or oversee worker management. Now, let's discuss algorithms. An algorithm is a set of instructions that a computer can follow to achieve a specific goal. In the human resources, software and applications use algorithms to assist employers in analyzing data and assessing applicants and employees and making decisions. These algorithmic decision-making tools are employed at the different stages of employment, such as hiring, performance evaluation, promotion, and termination. Artificial intelligence is a term that is evolving in public understanding. As defined by Congress, AI refers to a system that operates based on human-defined objectives and can make predictions, recommendations, or decisions that impact real or virtual environments. Algorithmic decision-making tools used in employment selection must comply with Title VII, which prohibits employment discrimination based on race, color, religion, sex, or national origin. Administrators can evaluate whether an algorithmic decision-making tool has adverse impact on a specific protected group by comparing the selection rates of individuals in that group to another group. What's a selection rate? It refers to the proportion of applicants or candidates who are chosen, hired, promoted, or otherwise selected. The selection rate for a particular group is calculated by dividing the number of individuals selected from that group by the total number of candidates in that group. For example, if 80 white individuals and 40 black individuals take a personality test scored by an algorithm as part of a job application, and 48 white applicants and 12 black applicants advance to the next round of selection, the selection rate for white would be 60%, and for blacks, it would be 30%. To determine if the selection rate for one group is significantly different from another group, a general rule called the 4/5 rule is used. It means a selection rate is substantially different if it is less than 4/5. That's 80% of the other rate. For example, where the selection rate for black applicants was 30% and for white applicants was 60%. The ratio of the two selection rates is 50%. Since 50% is less than 80%, according to the 4/5 rule, the selection rate for black applicants is significantly different from the selection rate for white applicants. This difference could indicate potential discrimination against black applicants. The 4/5 rule is a general guideline. It's a practical and easy-to-use test that can provide an initial indication of substantially different selection rates between groups, prompting administrators to gather more information about the specific selection procedure. However, the 4/5 rule is not always sufficient, especially when it does not serve as a reasonable substitute for a statistical significance test. Therefore, compliance with the 4/5 rule may not be deemed adequate by the EEOC to demonstrate the legality of a selection procedure when challenged in the discrimination charge. Given these factors, when you consider relying on a vendor to develop or administer an algorithmic decision-making tool, you should specifically inquire whether the vendor used the 4/5 rule or statistical significance when assessing the tool's potential adverse impact based on protected characteristics under Title VII. Are administrators responsible for the use of algorithmic decision-making tools even if they are designed or administered by another entity? In general, the answer is yes. For example, if you use a selection procedure that discriminates based on a protected characteristic, you can be held accountable under Title VII, even if the procedure was developed by an external vendor. Moreover, you may be liable for the actions of other agents, including software vendors, if you have given them authority to act on your behalf. This includes situations where you rely on the results of a selection procedure administered by an agent. When you consider using a software vendor to develop or administer an algorithmic decision-making tool, you should inquire whether the tool disproportionately impacts individuals with protected characteristics. If the vendor confirms that the tool is expected to result in significantly lower selection rates for individuals based on their race, color, religion, sex, or national origin, you should assess whether its use is job related and consistent with business necessity. You should also explore other options that serve your needs with less disparate impact. If the vendor's assessment is incorrect and the tool does result in discriminatory impact or treatment, you can still be held liable. If you, as an administrator, discover that an algorithmic decision-making tool has adverse impact, can you modify or switch to another tool to reduce or eliminate such impact? Generally, if you are in the process of developing a selection tool and realize its use would result in adverse impact on individuals of a particular sex, race, or other Title VII protected group, you can take steps to minimize the impact or opt for an alternative tool to avoid engaging in discriminatory practices prohibited by Title VII. Failing to adopt a less discriminatory algorithm that was considered during the development can lead to liability. As administrators, it's crucial to be mindful of the potential implications and responsibilities associated with the use of algorithmic decision-making tools in employment selection. By understanding the principles of Title VII and being vigilant about potential adverse impacts, you can ensure fair and unbiased decision-making processes.